Good evening, viewers, and welcome to Elombah Television tonight. As you are well aware, on the 17th of September 2020, President Muhammadu Buhari signed the Nigeria Police Bill 2020 into law. The special advisor to the president communicated Buhari's assent to the bill in the memo dated 16 September 2020. Speaking about the newly signed law, Mr. Desina said, the act repeals the Police Act 2004 to provide for a more effective and well-organized police force, driven by the principles of transparency, accountability in its operations, and management of its resources. Among others, the Act establishes an appropriate funding framework for the police, in line with what is obtainable in other federal government key institutions. Since the signing of the bill, however, there have been several controversies with regards the effect on this bill on the powers of the police to prosecute crimes. Not just the police, the powers of other federal law enforcement agencies to prosecute crimes in Nigeria. Lawyers have debated the issue, and so tonight we have eminent lawyers in our midst to discuss this topic, tonight being the new Nigeria Police Act 2020, its effect on criminal prosecution. With us tonight is Mr. Isaac Ogbah, Principal Partner, Ogbah Esq and Co, Editor-in-Chief, Erudite Judgments of the Supreme Court. Mr. Isaac, you are welcome to the program.
Thank you very much, sir.
Also with us tonight is Mr. Emmanuel Ewere Esq. He's an international business law expert of Advocate Lawyers, Abuja. Mr. Ewere, you are welcome to the program.
Thank you very much, Mr. Daniel. Always a pleasure to be here.
We also have Mr. Obunike Ohaegbu Esq. He's the Managing Partner, Senfil Associates, Abuja, Federal Capital Territory, Nigeria. Mr. Ohaegbu, you are welcome to the program.
Well, thank you for having me.
Last but by no means the least is Mr. Sylvester Udemezue. He's a lecturer and legal practitioner at Nigeria Law School, Victoria Island, Lagos, Nigeria. Can we start with Mr. Ewere, please? What do you think about this new Nigeria Police Act 2020? What is your opinion on the law? Are you muted? Unmute yourself, please. Yes, go ahead.
Yes. Thank you very much, Mr. Daniel. I would like to say that there is less or no difference between the 1943 Act and the current one. Basically, they just aligned the act with the provisions of the ACJA. Nevertheless, they still retained the power of the lay policeman to prosecute. And this is more of a challenge to the Nigerian system because we already have a complex system where the office of the Attorney General is fused with that of the DPP. Now making the police have the investigative right and also the prosecution right. These are two collisions that will not give a system a fair balance. This will bring about conflict of interest. This will bring about distraction and also no justice, actually, I would say, or low impact of justice. So I'll try to compare some of the 1943 provisions and also the current act that has been made out. In as much as the prosecution of criminal matters is vested in both the police, lawyers, and also the police and lawyers. Nevertheless, the Nigerian judicial system has suffered several inadequacies in the areas of prosecution. And I will focus my attention more on the conflict of interest of where a policeman finds it difficult to stand trial with a lawyer that has gone through the process of education and understanding how evidence and the procedures of criminal trials are being done, and a policeman that is trained to promote law and also enforce the law. Now, most of these lay policemen having the knowledge of arrest, investigation, and enforcement of the law come to court and try to muzzle out an experienced lawyer that has gone through the rudiments of the practice. Actually, in 1943, when they brought in the lay policemen, this was due to the low. We had very few lawyers then, so this empowered policemen to actually handle prosecution, just like how in the Constitution it gave the president a qualification of the ordinary in short, if a president can even read and write, you're qualified to be the president, not just the O level. So that was how the policeman was actually given the power to prosecute. Then we had few lawyers and even lay magistrates presided over criminal trials back then. But looking at our contemporary time, where we have a lot of lawyers, we have able hands and competent hands, I think that the current law is supposed to promote an efficient pattern, bringing in a law that will promote only lawyers, only those that have been trained in the act to prosecute. So the failure of this, because section 66, yes, section 66 of the Act that made provision for the powers to prosecute, just made reference to subject to section 174 and 122 that vested the power of the Attorney General to prosecute. Now, it actually gave the police to work based on the supervision and guidance of the Attorney General. Nevertheless, it did not restrict lay policemen from prosecuting. So I think we still have a challenge in the system. We still have more work to be ready to give substantial justice to our criminal justice system. So I think they have to go back to the drawing board and get something substantial. Thank you very much, Mr. Daniel.
Yes, we thank you very much, Mr. Ewere, for this introduction to this very, very important topic tonight. We're happy to announce that Mr. Sylvester Udemezue has joined us tonight. Now, he's a lecturer at the Nigeria Law School, Victoria Island. So we welcome him to the program. But meanwhile, let's call on our next speaker tonight, Mr. Ohaegbu. Are you able to speak on what do you think about this new Nigeria Police Act?
Well, I don't really know whether to say there is an improvement. I think the only area I could say that something has been done, today you could predict the tenure of the Inspector General of Police. When I was a federal commissioner, within the space of 3 years, I had to, because I work with Public Complaints Commission, so was had to collaborate with the police. Within that 3 years, I think I had to work with about 4 commissioners of police in FCT and about 2 or 3 Inspector General of Police. And I don't think it's good for the system. And at some point, there was a time we had issues in the build-up to the 2019 election, whether the then police, IG of police was going to stay till after elections or had to leave before election. If everybody knows that somebody who has been appointed now is going to stay for 4 years, you start counting from the day the appointment was made, irrespective of how long he has remaining in service. I think that one is settled. Another thing is that somehow it has helped to ensure that a particular set of people will be appointed, because a situation where a commissioner of police will be appointed, considering the nature of the police work, everybody, his senior, has to leave for the Commissioner of Police to be Inspector General of Police. Everything that has been put into the training of all the officers gone down the drain, and its nation will lose billions of naira on that. And in some cases, when such appointment is made, you find out that the Commissioner of Police was not really worth the sacrifice the nation made to have him as the Inspector General of Police. I think that matter is settled, but has made us better secured. If you look at the new act, what they did was to lift certain provisions from the Constitution, especially the Chapter 4, and then from the Administrative or Criminal Justice Act 2015, and just vomited them there. I don't know the difference that would make there, because assuming the SCJ is amended tomorrow, that means you have to amend the Police Act. Assuming the Constitution is amended tomorrow, you still have to. Will that still be the law? So to that extent, I think they have actually done well. But if you ask me, have they really done anything? What we need to do to be better secured in Nigeria is to do something very, very fundamental, and you have to go to the foundation of policing in Nigeria. Today, with amended act, somebody who has a petition in relation to a matter that has to do probably malicious damage to property in Ogbah South local government, where I come from, you could still submit petition to the Inspector General of Police here in Abuja. Cases like that, there are usually the need to visit the local SINCO. So the Inspector General of Police here in Abuja, his team will move down to Ogbah South local government to see what I have complained of. I don't think such is sustainable. The problem we have in this country is that we are not telling ourselves the truth. If they want to amend the Police Act, we have to have state police. Sorry to move into that, but I need to be realistic. We need to have state police. And the irony of it is that most governors who are protesting against that, all of them have state police in their states. I don't know what you call LASMA. The other day, a Sharia police officer arrested some people in Kano because they were drinking alcohol in clubs. What is that? The Sharia police officers, what will you call them in the context of the Nigerian Police Act? So why are we deceiving ourselves? Why can't we actually tell ourselves the truth that we need the state police? We need the state police. If you could look at what is happening in the judiciary, the assumption, if we could allow the state governments to appoint the CJs, judges, and all that in the states, and nobody is complaining, why can't we have the police? Because whatever the police does still ends up in the courts. If that concession to actually allow the state government for us to have state high courts, while still have federal high courts, both of them existing in the same state. As we speak today, we have federal high courts in Oka. We still have Anambra State high courts. Why can't we define some areas? Why can't we agree that there is the need for us to have that? If you go to Anambra, you have the Mpiawazo people. I'm trying to remember the name they are called. Are those guys not state police? So we need to go beyond the cosmetic amendment of the Act, the Police Act, and do the fundamental thing. I've read the Act. I've gone through it several times. The relation to community policing, I'm not sure I understand it. How communal is the policing when the instructions will still come from Edet outside in Abuja? So I think something has to be done. They've done something. Probably people have to, add in their campaign that they sponsor the amendment of they supported this and they supported that. Somebody probably a party has to say that You know, we amended the Police Act and all that. Fantastic. But something more radical should be done. And I believe that what you have now is a little bit short of what I expect and I was expecting that should be done as regards the amendment of the Police Act. Thank you, Daniel.
We thank you very much. We are already receiving questions at this point, but please, I crave your indulgence to wait. Those who are asking questions, we allow our discussants to present their views first, and then the question and answer time will follow. Thank you very much, Mr. Ohaegbu. We'll next listen to Mr. Ogbah, please. What do you think, Isaac, please, on the new Nigeria Police Act? Has anything changed, or for better or for worse?
Okay, thank you very much. It's a pleasure being here tonight. The topic again is the Nigerian Police Act 2020. Implication for criminal prosecution. So it's a broad topic. I will do my best to try and bring out some salient points that I found interesting in the act itself, whether it will be helpful or dangerous. On the first issue that was raised regarding lay persons, policemen, being able to prosecute matters in court. If, with permission, I would love to read that section 66(2) again. It says, a police officer may, take note, it's not shall, may, subject to the provisions of the relevant criminal procedure laws. I repeat again, subject to the provisions of the relevant criminal procedure laws enforced in the federal or state, prosecute before the courts those offenses which non-qualified legal practitioners can prosecute. The question is, are there offenses that non-qualified legal practitioner can prosecute? The answer is no. The fact that you said that they can, and there's such, in federal state level, we have ACJA. Section 106 of Administration of Criminal Justice Act stated in clear terms that, permit me to read again, prosecution of all offenses in any court shall be undertaken by only the following persons. Take note. The express mention of one thing is the exclusion of the other. Who were those that were listed as in general of the Federation? The law officer in the office of Ministry of Justice or Department, a legal practitioner authorized by the AGF, a legal practitioner authorized to prosecute by this act or any other act or National Assembly. Take note, this is the ACJA, listing those that can prosecute under that federal aspect of the law. And many states have also domiciled this ACJA in their various states. And thank God, the way when you were introducing our learned lecturer, Sylvester Udemezue, he has written so many articles, so many publications in respect of this. And in one of his write-up, he summarizes, he said this is subject to the provision of the Constitution related to powers of the prosecution by the AG. The Act goes further to provide that all charges filed to commence criminal prosecution in the magistrate court to which Act applies must be signed. What I'm trying to say is the word. No, this new law talks about subject to the provision of the relevant criminal procedure enforced at the federal or state. In the states under the ACJL, who are those qualified to practice to prosecute matters in court? You either have either the Attorney General Federation, the law officers of the AGF, as the case may be, or the world, the Attorney General of the state, legal practitioners acting under authority of the AGF, a public officer prosecuting in his official capacity under the direction of the AGF, and any other person so authorized by the AGF, a private prosecutor, a police officer, who is equally a lawyer. Take note, there are so many decisions on the world there, other prosecuting authority. The question I'm asking is, well, from the ACJL that many states have, on the law itself, police officers are not listed. From the ACJL of many states and on the federal level, police officers are not listed. And this law we're talking about right now says, subject to the provisions of the relevant criminal procedure laws enforced in the Federal Capital Territory. So if this new Police Act is saying that it is subject to those laws, so we must definitely have a recourse to those laws. And what is the extant laws guiding prosecution in the current war? Is the ACJA in the federal courts, ACJL in the state courts, as the case may be. So if there is no policeman provided for in the ACJA and the ACJL, and number two, it says, shall prosecute before the courts those offenses which non-qualified legal practitioners can prosecute. Except I stand to be corrected. Are there laws, are there offenses listed that laymen can prosecute? I have not found any of such. I stand to be corrected. Then number two, I found section 66 sub 3 very interesting. It said there shall be assigned to every police division at least one police officer. We're talking about criminal prosecution. Where do we have many problems from all this while? Many a times, policemen will draft charges that are spurious. And when you come to the court, because of their inexperience, not legal training per se, a lawyer will floor them. A complainant who has a bona fide complaint, good petition, but because of the inexperience of police officers, they lose cases. But with this provision, we now have as well that there shall be assigned to every police division at least one police officer. That means it presupposes that what? If every police division has a lawyer assigned there, before any IPO drafts a charge and goes and files it, what? The lawyer must vet it. And if the lawyer vets every charge that is going to the court, you should be rest assured that what? Every charge that is filed in court should stand a chance of success. Before taking any matter to the court, the lawyer would have seen the facts of the case. Is there a prima facie case? If not, a lawyer who is what is not would not be pushed about to go and file a spurious charge. So I think that's section 66, sub 3, very interesting word. So I also find so interesting section 69. We're talking about, because it is holistic, the new Nigeria Police Act 2021, implication for criminal prosecution. Many a times we have people detained arbitrarily at the police station, languishing there. No respect for them. Section 69 provides, 69.1 says, an officer, so somebody is the word, police officer shall report to supervising magistrate. So the whole section 69 talks about what? A police officer who is heading any police division, either command, they are answerable to a magistrate who will be visiting them periodically. Says every month, an officer in charge of a police station or an officer in charge of any agency authorized to make arrest on the last working day of every month. So the word is shall. On the last working day of every month, report to the nearest magistrate the cases of all suspects arrested without warrant, the limits of their respective stations or agency, that's a list of bail or not. If you go down, you also talk about even judges also. Truth be told, what if police officers and other agencies that are prosecuting, arresting, detaining people can comply with this law, it will bring about some transparency and people will not be detained arbitrarily. Then lastly, if there was something I found so interesting, which I really want to point out, because if we don't treat it now, we may have serious challenges in the long run. Section 130, please, if you permit me, Section 131, Chapter 15, introduce what we call police, public compliance, and discipline. There's what I want to talk about was the General Police shall establish a public police complaints response unit, ICROU. In this act refers to as the unit in the force headquarters and each of the police commands in all the states. Two sections say, and then 132 says what the unit shall consist of. Okay, then 133 talks about what the unit shall receive complaints or information of police officers' misconduct from the public. Complaints of police officers' misconduct from other police units or authority. Though this section is supposed to be for complaints against policemen in their conduct, unfortunately, this section somehow may be used arbitrarily by this CROU unit to discontinue cases that are pending before the court. Why am I saying so? Let's assume that a police officer investigated a matter and the matter is already in the court. The matter is ongoing. A complaint is written to the CROU against the legal officer who files the charge or against the IPO who investigated the matter. And based on the system that we have, the cut-off system, I can tell you authoritatively, tendencies are there that matters already going in the court because of allegations leveled against police officers who investigated. Such matters are being withdrawn. I can give you authoritative word. I have a matter already before the court already. And because this unit already has the legal backing by this police act, petitions are being written against the legal officer who is the prosecutor, complaints are being written against the IPO who investigated the matter, and the CROU is telling you that well, they have power to order them to withdraw matters when you have prima facie case. So to get a sense, what problem we have in Nigeria is not the issue of law, but the implementers, those who implement it. Section 66 does not say policemen can prosecute expressly. It is still subject to the relevant laws. But I'll tell you, in actual fact, policemen will hold onto that section and say they have power. Their powers are limited. I don't know of any law that says laymen can prosecute. I don't know of any offense that says laymen can prosecute. But with that section, those who want to implement the law will use it arbitrarily against innocent citizens. I stop for a while for now. Thank you very much.
We thank you very much, Mr. Ogbah, for such an erudite explanation of some of the dissection of some of the sections of this new Nigeria Police Act. We have Mr. Sylvester Udemezue with us now. He's a lecturer and legal practitioner at Nigeria Law School, Victoria Island, Lagos, Nigeria. Mr. Udemezue, you are welcome to take the floor. If I can unmute you.
Thank you very much, sir. Thank you very much. God bless you. Thank you very much, gentlemen. I hope everybody can hear me now. I hope I'm properly connected.
Yes.
I hope I can be heard.
Yes, we are hearing you. Go ahead.
All right. Thank you very much. I thank all of you and for the wonderful contributions we have been treated to so far. Now, I think I'm told that I have just 10 minutes to start the program, that's to talk. And I would like to start from the very first issue, which is what brought us on the topic we have for discussion today. There are so many things to be said about the new Police Act. We can spend the whole day discussing that law. There are so many things, and I hope that the organizers of this program will make our time to take up all other aspects of this program. So I would like to start from this prosecution of cases by police officers. Now, having listened to the last speaker, Mr. Ogbah, my very big learned friend and brother, I would like to say that with due respect, the truth of the matter is that police officers are still empowered to prosecute cases in Nigerian courts. That is what the implication, the first thing that must be said, because we are not going to rely on only the provisions of the ACJA or ACJL of some states to decide whether police officers have the power now to prosecute cases in Nigerian courts. We also have to look at decisions of courts of law. And if we have to go down memory lane, we would discover that this all started with, of course, they have been prosecuting cases like Mr. Ogbah pointed out, that this started because we didn't have sufficient number of legal practitioners at the beginning. Just like even non-lawyers, used to practice law in Nigeria. It was in 1914 that the Supreme Court, the Chief Justice of Nigeria, banned all aspects of practice of law by non-lawyers. And it was Mr. Osho Davis who made an application to practice as a self-taught attorney. And the CJN refused that application and said the era of self-taught attorneys or non-lawyers practicing in Nigeria is gone. So I wonder, I am still surprised that non-lawyers were stopped as far back as 1914 from practicing law in Nigeria. But police officers who are not lawyers are still allowed to continue to practice in court, to continue to practice as if they were lawyers. Now, this is because a decision of the Court of Appeal in the case of Olushemo and COP, that Olushemo and Commissioner of Police reported in 1998, 1 Nigeria Weekly Law Report, part 575, page 547. It was in that case that the Court of Appeal declared that any police officer can prosecute a case or cases in all superior courts in Nigeria, but such police officers should have been called to the Nigerian bar. In other words, Olushemo and COP made it clear that for any police officer to prosecute a case in any court in Nigeria, he should have been called to the Nigerian bar to prosecute. If you had to prosecute a case in any court apart from inferior court, like High Court, Court of Appeal, and the Supreme Court, and you are a police officer, you must be a lawyer. That position was okay, but it authorized police officers to prosecute in inferior courts, like magistrate courts, area courts, and so on and so forth. Now, this continued until the case of Osaho, or Federal Republic of Nigeria and Osaho. The Federal Republic of Nigeria and Osaho. That was a Supreme Court decision in 2000, reported in 2006, yes. 5 Nigeria Weekly Law Report, part 973, page 361. It was in that case that the Supreme Court now declared, and I quote, that all police officers, whether or not they are qualified as lawyers, were entitled to appear and prosecute cases in all courts in Nigeria. So with that decision in Federal Republic of Nigeria and Osaho, the decision in Olushemo, which restricted practice by police, non-qualified or non-lawyer policemen to only inferior court, was overruled. So the authority now became the case of the Federal Republic of Nigeria and Osaho. That meant that any police officer, whether you're a lawyer or not, can take up a case and prosecute from the magistrate court to the Supreme Court. There was no bar. Of course, I want to take our attention back to what Honorable Justice Oliver Wendell Holmes, of a former Justice of the United States Supreme Court said that the prophecies of what the court was, whatever the law is, whenever interpreted by the court, whatever court says about that becomes the portion of the law. So Federal Republic of Nigeria and Osaho continued to operate until when the ACJA in 2015 came on board.
That is it.
So the ACJA came on board in 2015. And when it arrived, it, of course, not to belabor this issue, because Mr. Ogbah has cited some provisions of the ACJA and also spoke about what the ACJA is saying. My conclusion or my opinion is that the ACJA has banned anybody who is not a police officer from prosecuting in the court where the law applies. But the truth of the matter is this: ACJA, Administration of Criminal Justice Act 2015, does not apply to all the courts in Nigeria. It applies to only few courts, the Federal High Court and the Federal Capital Territory. In other words, the ACJA, the Administration of Criminal Justice Act, does not apply to any state high court in Nigeria. It does not apply to any magistrate court apart from the magistrate courts in the Federal Capital Territory. So it applies to only 3 courts: the High Court in the Federal Capital Territory, the magistrate courts in the Federal Capital Territory, and all Federal High Courts in Nigeria. So what about all the states in Nigeria? Their high courts, their areas, so on and so forth. What about those ones? Act 2015 has not banned non-lawyer policemen from prosecuting cases in any court to which that act applies. Police officers who are not lawyers had continued to prosecute cases in all other courts in this country. So not much progress has been made, if you look at it that way. While the Administration of Criminal Justice Act has done a lot of things to say, okay, police officers who are not lawyers should no longer prosecute. It must be said that until this is extended to all other states in this country, we will not say that police officers have been banned. That was the position. Now, there were a lot of writings from lawyers and interviews and programs, okay, people calling for that police officers should just be absolutely banned from prosecuting cases in Nigeria because they're not lawyers and they can't handle cases that lawyers handle. They can't even prosecute. The truth of the matter is that police officers cannot prosecute cases except they are lawyers. If you're not a lawyer, you can't prosecute a case. And you can't face a lawyer in court, like Mr. Ogbah pointed out. You can't come to court and stand before a lawyer. Imagine Mr. Sylvester cross-examining a witness in the witness box, for example, and the police officer will be on the other side. We all know that when you're cross-examining your witness, there will be a point where the counsel on the other side will need to object to some things. So when I get to court, whenever I handle a case with the police, I say whatever I like in court. He can't do anything because he doesn't know what the law is talking about. So it is a very ugly scenario that we have police officers in this country prosecuting cases. So this continued, the position under the ACJA. I can say now that what the ACJA did in 2015 was to just a kind of ban prosecution by police officers in just about 3% or even 2% of all the courts in Nigeria. Because the Federal High Court and the courts in the FCT represent only 2% of all the courts in Nigeria. So what about the other 98%? It continued. So Ebonyi State and Kano State, in their ACJL, until today, the Lagos State government, or Lagos State that took the lead in the enactment of the ACJL, has not banned police officers from prosecuting cases. In Lagos State, police officers still prosecute cases in courts. So the ACJL, the Administration of Criminal Justice Law, Repeal and Reenactment Law, Administration of Criminal Justice Repeal and Reenactment Law of Lagos, 2011, did not ban police officers from prosecuting cases. So that continued in Lagos State. Now, Ebonyi State took some steps to try to ban police officers. Then there was this news that Kano State tried to, when they brought their Administration of Criminal Justice Law, that they also banned police officers from prosecuting. But when we now took a careful look at the Kano State Administration of Criminal Justice Law, it was noted that police officers were still permitted to prosecute cases. If I may be permitted, let me read a section of the Kano State Administration of Criminal Justice Law as it is, so that we will see that in Kano State, although the news out there is that in Kano State, police officers, in fact, the AG, the Attorney General of Kano State, was commended for leading the fight or the crusade that led to the banning of police officers from prosecuting cases. Unfortunately, when you now take a look at the law itself, you will discover that there is still room for police officers to prosecute. I'm coming to the Nigeria Police Force Establishment Act 2020. I'm trying to just go down memory lane for us to understand what had happened before the 2020 Act. So that was why I personally am not happy with the 2020 Act, because a lot of things had happened. We expected much more than what the 2020 Act had done, because today the confusion still persists. That's my position. But I'm going to come to that. Let me just refer us to that position of the law in Kano State. And that is what many states have adopted. Now, section for Kano State, just a second, I'm trying to bring it up. Now, yeah, the section 123, subsection 2 of the Administration of Criminal Justice Law, Kano State, provides, please permit me to quote verbatim, nothing in this section shall prevent a police officer from prosecuting any offense triable by any magistrate court. I repeat, nothing in this section shall prevent a police officer from prosecuting any offense triable by any magistrate court. That's section 123, subsection 2 of the Administration of Criminal Justice Law, Kano State. So with this, it is obvious that what Kano State has done is to repeat the position in Olushamo and COP. Police officers who are not lawyers can still prosecute at the magistrate court. And if they can prosecute at the magistrate court, they can prosecute at the area court, which is the equivalent to magistrate. This is also on the same level with the magistrate court. The only courts that police officers who are not lawyers are banned from prosecuting cases in Kano State are High Court, Court of Appeal, and of course the Supreme Court. So, which means in Kano State, police officers are still allowed. And as far as I'm concerned, Kano State has done nothing because police prosecution is majorly seen at the magistrate court. So, if a law comes up and you still allow them to prosecute at the magistrate court, you have done nothing, as far as I'm concerned. So, all the commendation and the congratulatory messages that were sent to the Kano State AG were over nothing. He has done nothing. When you allowed police officers to continue to prosecute at the magistrate court, and like Mr. Ogbah said, more than 70% of the cases at the magistrate court are frivolous because of this. Now, this was the position, and Administration of Criminal Justice Law of many states continued that way, and that was a very ugly scenario. So, police officers who are not lawyers continued to prosecute cases in court until last month, when the Nigerian Police Force Establishment Act 2020 was signed into law by President Muhammad Buhari. And then looking at section 66 of that particular law, with due respect, I'm sorry, my very good brother and learned friend, Mr. Ogbah, I have to respectfully differ on this position. Section 66 makes it very clear that police officers can prosecute. Like you cited, you said the section 66(2) says a police officer may, subject to the provisions of the relevant criminal procedure laws in force at the federal or state level, prosecute before the court those offenses which non-qualified legal practitioners can prosecute. What this means, that's section 66 subsection 2. Yeah, a police officer, section 66 subsection 2. A police officer may, subject to the provisions of the relevant criminal procedure laws in force at the federal or state level, prosecute before the court those offenses which non-qualified legal practitioners can prosecute. Now, the question is, what is this section talking about? What is the implication of this section with respect to prosecution of criminal offenses by police officers? The use of may is automatically giving police officers right. If you say, Mr. Sylvester may come in, what it means is that I'm entitled to come in. In other words, if I want to come in, I can come in. If I don't want to come in, I should not come in. Once you say, Sylvester, you may come in, it's another way of telling me that, look, you are entitled to come in. So if you choose to come in, what that means is that every police officer who decides to prosecute a case in court today can still prosecute. And of course, we know that those police officers who are prosecutors will want to continue to prosecute. They will never want to stop because they know what they are getting. Corruption is on their head, with due respect to them. They are so corrupt, many of them, sorry to say that, many of them are so corrupt. All they're interested in is collecting money from defense counsel, from defendants, from complainants, and doing all sorts of shady deals. So they will want to continue to prosecute. So this section is a very, very setback on the administration of criminal justice in this country. It's a serious setback. So the section has continued to prosecute, has allowed police officers to prosecute. When you say, I may prosecute, it's another way of telling me that I'm entitled to prosecute if I choose to do. In other words, it is left for me. If I want, I can. If I don't want, it's left for you. Now, let us take, it says, subject to the administration of criminal justice laws of the states. Let us take Kano State, for example. The question is, can a police officer prosecute in Kano State based on section 66(2)? The answer is yes. Because it says subject to the law. In Kano State, the Kano State law says no police officer who is not a lawyer can prosecute at the High Court. So in Kano State, application of the section 62 in Kano State now is that police officers can prosecute in all courts in Kano State apart from Superior Court. Because Kano State law permits non-qualified legal practitioner to prosecute. Although the term non-qualified legal is absurd, it is senseless, it doesn't have any meaning. I wonder where they got it from. But the most reasonable interpretation we can give to that term non-qualified legal practitioner is a person who is not a lawyer. Let us face the truth. If we look at it critically and reasonably, the closest definition of that term is a person who is not a lawyer. So what the act is saying is that police officers can still prosecute in all the courts where non-lawyers are allowed to prosecute by state or federal laws. So now coming to the Federal Capital Territory, that section cannot apply because ACJA has banned police officers from prosecution in all the courts. So Section 66, Subsection 2 of the Police Act 2020 cannot entitle a police officer to prosecute at the Federal Capital Territory because ACJA has banned them. Now, Section 66, Subsection 2 cannot entitle the police officer to prosecute at the Federal High Court because the ACJA has banned them there. But in every state in Nigeria where police officers have not been prohibited, expressly or impliedly prohibited from prosecution, Section 66(2) they can still rely on Section 66(2). That's the implication of the use of the word. In line with Section 66 of Section 2 of the Nigeria Police Force Establishment Act 2020 is that all police officers who are not lawyers may prosecute criminal offenses in any court in any part of Nigeria, provided that they are not banned or prohibited from doing so by the law in force in that state, period. In Kano State, for example, Section 66(2) authorizes the police officer to prosecute at the magistrate court because Kano State law has banned them from prosecuting in high courts and other courts.
All right, thank you very much. Thank you very much, Mr. Udemezue. Because
so this is what I think that my time is gone for this. I just wanted to start from that power of prosecution. So I will go to other issues as we progress. Thank you very much. God bless you.
We thank you very much. We know you have a lot to say on this subject, having written a lot of articles on them as well. So I think it is now time to take questions from the audience. If you have any question, now is the time to ask them. My first question will go like this to our discussants. Seeing the controversy surrounding the power of the police to prosecute, do you think Section 66 should be removed entirely from the provision? Because I have the opinion of Mr. Kemi Pinheiro-san, who said that it is anathema for the police to undertake prosecution in any form whatsoever. Also, Chief Ferdinand Obi-san said that for an investigation agency to carry out any prosecution of crime they investigate, it's an offense against all known principles of fairness. Now, in order to clear the ambiguities being identified here, do you think that Section 66 of this new Police Act should be abrogated in its entirety? Let's start from Mr. Emmanuel Ewere this time again. Is Emmanuel still here with us?
Thank you very much, Mr. Daniel.
Yes.
Yes, I would like to emphasize that there is a chain in criminal justice. And in this chain, the first point is detection of crime. The second point, investigation. The third, gather evidence. The fourth, then arrest. After arrest, then you hand over for criminal trial. That is when the criminal trial proceedings will take effect. So now, in the Nigerian system, how they operate is that they will detect a crime, they will run to court, file a very defective charge, then apply to the court to further remand the person pending the determination of the investigation, not even the trial. So they will now go back and start investigation. Let me give a practical example so that the whole thing will be very clear. We actually saw how the American Interpol handled the hush puppy arrests, how they took their investigation gradually and gathered all the evidence and arrested him and handed him over for trial. Now, back in Nigeria, we saw a similar scenario where the EFCC now that actually have right to prosecute as well, arrested Mofa. Immediately after the arrest, they charged him to court, collected a remand warrant, kept him and started investigation. Now, they started the proceedings with very, very, very inadequate evidence. Then at a point in the trial, they tried to change things but things were not working anymore. Now Americans they have had the first conviction on Hush Puppy and he's going through more trials. But Nigeria, they're still struggling with the prosecution of Mofa. So we have two clear scenarios here. Now look at the difference between these two sides. The police handled the detention, the investigation, the gathering of evidence, and a department for prosecution, they're handling the legal aspect of it. This is a balanced system. Now in Nigeria, we're looking at the police. They will do all the investigation, the gathering of evidence, and they will now do the prosecution. So, you have this combination of two powers that cannot really flow together. Looking at their training point, the police are trained in a different field. Now, coming to court to handle this with legal minds that have the experience, this will not balance. So I think that Section 66 really, really, really is inadequate and cannot really hold weight in criminal system, especially the B paragraph, where it is stated may, and they made it very, very complex. And I don't think it's a lawyer that drafted the B pack, because the way it is constructed, it is not even clear to a draftman, I'm sure. So we have a lot to do to our justice system. If truly justice should be done, then we must severe this aspect. Make sure lawyers are not trying to protect their job. Lawyers are not trying to grab all the debrief policemen. No, we're trying to see how the flow of justice, the chain of criminal system can be effective. That is the key. That is the drive behind the whole prosecutorial rights vested on lawyers. It is not to debrief policemen, but it is to ensure, because in prosecution, there is no win and there's no lose of a case. An exception to this is where a prosecutor gets a judgment with insufficient evidence. I tell you, that is a lose. It is a big lose. And where a prosecutor refuses to get conviction with sufficient evidence, that is another big lose. Now, but the general principle is that there is no lose. The basic focus of criminal proceeding is justice. So if this justice must be attained, then it should be done by qualified hands. And we have a lot of these hands available in the country. We have so many persons competent, capable, and willing to prosecute. So why not get the system into order? Get it to the proper persons to do this thing right, instead of getting policemen that at the end of the day, they will either try to amend charge. If they are not amending the charge, they're trying to cut a side deal with the suspect.
All right, we thank you. Thank you very much, Mr. Ewere. That's for your fine. Before I call on the other speakers to answer some other questions coming up, well, Mr. Bethel Ihuba, please, has indicated that he has a comment to make on this point or a question to ask. So, Mr. Ihuba, are you able to? I have asked you to unmute. You can unmute yourself. Yes, go ahead.
Thank you very much. Can you hear me, please?
Yes, I can hear you.
Hello?
Yes, go ahead.
Okay, thank you very much. Thank you so much. Thank you for organizing this program. I do really appreciate it. May I thank each of us thank two persons first before I continue. Mr. Sylvester, Prof, thank you very much for coming down. And my able senior, Isaac Ogbah. Well done, sir. Yes, you see, there appears to be, I listened to Sylvester now, and for me, with due respect, sir, I think he's on the, that is actually not our problem. Even is the fact that single group of people. And why we have this problem of somebody put something recently on in the afternoon on the what the police people do at the police station. The threat of prosecution is used against defendants, so to say, and they are forced to start maybe giving bribes. Police are able to do that because they believe.
I think his network is frozen, or is it me?
I think his network is frozen.
Okay.
He'll be back. So we'll just continue.
Do I try to respond to your question while we wait for him?
All right, go ahead, Mr. Huber, if you are back. Okay, no. Okay, Mr. Ohaegbu, can you respond to the question now? Yeah, go ahead.
Okay, your question is specifically on section 62, section 66.
Yes.
The ordinary out is to say, okay, I'll remove that section that says non-qualified legal practitioners can prosecute. That is subsection 66, subsection 2. A police officer may, if you permit me to read, a police officer may, subject to the provisions of the relevant criminal procedural laws, enforce at the federal or state level, prosecute before the courts those offenses which non-qualified legal practitioners can prosecute. The first question that that came to my mind is, who is a non-qualified legal practitioner? Because it's either you're a legal practitioner or not. Even if this section is expunged, from the Police Act, will that actually stop a police officer from prosecuting in states where they are allowed to do so? Because this the person who is going to prosecute is going to prosecute with the laws that are applicable in the states. We know that the ACJA has not been domesticated by all the states of the Federation. So when you go to Kano to prosecute, you need to work with what they have. So even if a policeman by the Police Act is allowed to prosecute, or is not allowed to prosecute, but the laws in Kano permit him to do that, what is he going to do? You see, there was, I could remember when this bill was being was passing through the statutory procedures in the National Assembly. The bigger question as at that time was whether this amendment should be done on the Police Act or should be done in the Constitution. Because if it's done in the Constitution, of course, automatically it's applicable everywhere in Nigeria. I wouldn't want to write off, because I wouldn't want at the end of the day we write off this amendment. It's not totally bad. When you talk about prosecution, the prosecution is the last lap. Before you get to the point you will decide whether to prosecute or not, there are certain basic things you must have done. For instance, if you look at this, the act now, it made extensive provisions for investigation, search, and all that. Equally made detailed provision for keeping criminal records. Of course, the problem is not about having the law. How do we How do we keep the data? If somebody is, if this is implemented, if somebody is arrested in Otonkom, the policeman who is doing the investigation is obliged to take his fingerprints and all that. Even if at the end of the day, the person did not end up in court. Tomorrow, if he's arrested in Ajokuta, if he moves from Otonkom in Benue State down to Ajokuta in Kogi State, if he does anything again and is arrested, the policeman in Ajokuta is supposed to see his criminal record. That way, the citizens are better protected because you already have an idea of the person you are dealing with. So to a reasonable extent, I will say that it makes no difference whether you expunge section 66 subsection 2 or not. Because if you remove it, it allows the police, it stops the police from prosecuting. But if you get to the state where you have to prosecute, and the law you want to use to prosecute allows you to prosecute, which one do you choose? It gives the police the opportunity to pick and choose. So if this amendment was done in the Constitution, it would have been of general application to everywhere in Nigeria. So for me, it makes no difference. Although, as I said earlier, I do not even understand what they meant by unqualified legal practitioner. Who is an unqualified legal practitioner? It's either you're a legal practitioner as provided by the Legal Practitioners Act, or you are not one. If you're not qualified, you're not one. So why would somebody who is not a lawyer be referred to as a legal practitioner, unqualified one? So my opinion is, in answering your question, it makes no difference whether section 66 is expunged or not. We need to find a way to make this amendment applicable to everywhere in Nigeria. And the best way to do that is to find a way to accommodate it in the Nigerian Constitution. Once it's accommodated in the Nigerian Constitution, of course, every state will be obliged to amend their laws to, to be in compliance with the provisions of the Constitution. Thank you at this point.
Yeah, we thank you very much. Please, our discussants, we have so many people indicating they want to ask questions and comments. So, but I will allow the discussants, please, to address this question and then please make it brief so that we will call on members of our audience who have seriously indicated the interest to comment to do so. Please, sorry?
I want to beg to say a word on this, a word or two on this matter, on this issue, this particular question, please.
Yes, go ahead.
And Mr. Ogbah is on board. Mr. Ogbah, please, I beg to just say something because Mr. Ogbah, he spoke before me when we were presenting initially. Now, let me start by saying that somebody talked about, was trying to show some kind of pity to the police or trying to explain to them. We don't owe the police any explanation. We don't owe the lay policemen. They don't deserve to prosecute, period. What is right must be done at all times. It is not about telling them, oh, sorry, this is not meant to sideline you or to take your jobs away. No, it is not their job, period. You don't do what you are not cut out to do. The job of the police includes to maintain order, prevent crime, detect crime, investigate offenses or crimes. They don't have any power of prosecution. It is not their job. The only business they have in court is to maybe appear as witnesses, as IPOs, period. That's number one. Number two, now, my learned friend that spoke asked, if section 66 subsection 2 is removed from the Police Act, would it make any difference? The answer is no and yes. No, because if you remove it, you still allow them to prosecute. Because where there is no provision at all on that matter, of course, if any state law permits them, they will prosecute. What should be done is not to expunge, it is to amend. And the question is, what a shape should the amendment take? I suggest that what should be done is to make an express provision prohibiting any policeman that is not a lawyer from prosecuting, period. Let section 62 provide no prosecution in any court in Nigeria shall be undertaken by a policeman unless he's a legal practitioner. When you make that provision, there will be no prosecution by any police officer in Nigeria, because the Police Act governs the conduct of police officers. So even if there is a state law that permits a police officer to prosecute, when there is an express provision in the Nigerian Police Force Establishment Act 1920 prohibiting a police officer from prosecuting, he cannot prosecute. Even if you tell him to come to Kano State to come and prosecute, he cannot prosecute because the law governing his conduct has banned him from prosecuting. So I think that if we have an express prohibition, so it is not expunging, it is amended to make it express that they should not prosecute anywhere. That is the law that governs them, and they will not prosecute. Finally, I want to just repeat a comment I made in a paper I did titled "Disengaging Lay Police Officers from Criminal Prosecution for a More Efficient Criminal Justice Administration in Nigeria." With respect to the question posed by my learned Sheikh, Chief Ferdinand Obi, I said, and I quote, "It is considered pertinent to recommend that relevant governments and stakeholders should, as a matter of urgency, set in motion procedure to do what? To amend all the laws in Nigeria. But there's no need. That's the end. Such move is long overdue. It will reduce the amount of delays currently being experienced in criminal proceedings and ensure a speedier and more effective administration of justice in Nigeria. Lay police officers' involvement in prosecution is partly responsible for worsening cases of awaiting trials. That's number one. It is partly responsible for worsening cases of awaiting trials and prison congestion in the country. Because of their professional limitations in this area, so many of the so-called prosecutors are not able to match or withstand the legal firework of professionally qualified lawyers who act as defense counsel in court during criminal prosecution. Because these lay policemen do not understand the intricacies of formal courtroom proceedings. There is no doubt that when lay police officers are finally disengaged, now, so let me just go to I don't want to waste our time. Now, the practice of using lay policemen to prosecute cases in Nigeria dates back to the colonial era. I've pointed it out, but the conclusion I make here is that there is need for us to immediately, as a matter of urgency, remove lay policemen from prosecution. And the best way, the only way to do it today, once you do that, all these matters will be taken care of. An express provision. Why should our lawmakers continue to run around issues? Do we like court cases? We like to make complex laws that will give rise to litigations in court. It's not proper. Let there be an express prohibition of prosecution by any police officer who is not a lawyer. Once it is done in the Police Act, they can no longer prosecute because that is the law governing their conduct as professionals. Just like the Armed Forces Act. If the Armed Forces Act says a soldier cannot go to Onitsha, he will never go there. Even if there's a law, a state law in Onitsha that says soldiers can come in, he is not entitled to enter because the law that governs his professional conduct has said he cannot go there. The Armed Forces Act is that the RPC, the rules of professional conduct of lawyers. Once he says a lawyer cannot do something, any law telling the lawyer to do it is of no use. So let there be an express provision in the Police Act prohibiting police officers who are not lawyers from prosecuting. That will solve the problem. Thank you very much.
Thank you very much, Mr. Ogbah. Please quickly so that we call on our listeners to. Okay, Mr. Ogbah. Are you muted?
Okay. The question is what? Can you hear me?
Yeah, please, I can hear you. Please quickly address this question. What do we need to do? Yes,
very simple.
Mm.
A non-qualified surveyor cannot sign a survey plan. A non-medical doctor cannot practice as a medical doctor. A non-engineer cannot supervise an engineering project. Then why should a non-lawyer prosecute? Very simple. Section 253 of the ACJL stated in clear terms, only a law officer can sign an information. It should also apply in magistrate court, only a law officer should be able to sign a charge sheet. The summary of everything is what? Lay policemen should not, people who are not lawyers should not be allowed to practice. I align myself totally with the submission of Sylvester Udemezue on this issue. Thank you very much.
We thank you. Please do not go away, because there are so many things in this Police Act apart from the power of policemen to prosecute. So I hope we still have to address those issues. So, but let us call on the some of our listeners here who have joined the program, who have indicated interest to say something on this fact. First of Mr. Vitus Esq, and then we will call back Mr. Bethel, please. But let's listen to Mr. Vitus also, please.
Okay. Gentlemen, thank you so very much for having this wonderful conversation. To be honest with you, this is the first time I'm actually developing a keen interest on the matter of police reform that is going on. And this is the first time I've looked at the provision of 66(2), and I'm just trying to understand it. But the principle here is simple. Police officers the world over do not have prosecutorial powers. We can establish a consensus on that. But I'm intrigued by the language of 66(2). So I'm going to ask one quick question, and that will inform my comment moving on. Are there courts in Nigeria, because we have different courts in Nigeria, are there courts in Nigeria where a lawyer in Nigeria will have to be specially qualified to practice? And let me make it simple. Is a lawyer, just by the mere fact that you've been called to the bar in Nigeria, are you qualified to practice in Sharia courts in up north? Or do you have to be specially qualified to practice law in Sharia courts?
Okay, that's okay. Thank you very much. That is a question.
No, I want somebody to answer that.
Can I quickly address that? That goes to Section 8 of the Legal Practitioners Act. Okay. Professor Vitus, nice to have you on this program. Nice to see you. Our exchange so many years ago. Thank you very much. So this, the Section 8 subsection 8 of the Legal Practitioners Act provides an express answer. Once you qualify as a legal practitioner, you are entitled to practice in all courts in Nigeria, without any exception. All courts, from number 1 to the last court. And that is Section 8, Section 8 of the Legal Practitioners Act, and then Section 2 of the Legal Practitioners Act now defines those who are entitled to practice generally, those who are entitled to practice by virtue of their office, and then those who are entitled to practice for the purpose of specific proceedings. Now, like lawyers who are in America or from London, who are not lawyers in Nigeria, if they want to come to Nigeria to prosecute a case or to handle a case, they can do so. All they need to do is to apply to the Chief Justice of Nigeria to grant them the permission to come and handle a particular case and go away. They're not supposed to take another case. But if you are qualified in Nigeria as a lawyer, having been called to the bar, to the Nigerian bar, you are entitled to practice law in all courts in this country, including Sharia courts, area courts, magistrate courts, Supreme Court, High Court, and whatever court you have, even military courts too, any court at all. And then when we now go to Section 24 of the Legal Practitioners Act, it tells us who a legal practitioner is. You know, so Section 24 defines who a legal practitioner is. Section 8 tells us the rights of a legal practitioner. In fact, those rights are exclusive to legal. That's why we are surprised. Those rights are exclusive. The right to stand in court and argue law as exclusive to legal practitioners. But the procedure of allowing police officers emanated from the foundation is Section 6, Section 36, Subsection 6C of the Constitution. We all know that the Constitution is the ground norm. Section 36, Subsection 6C of the Constitution says a person who is accused of commission of a criminal offense is entitled to defend himself in court without the need to call a lawyer or to call a lawyer of his choice, which means I can come to court and stand and cross-examine the other witness on the other side without calling any lawyer. I can do that. That is what led to the practice of allowing a police officer to come to court to talk law, which is not ordinarily is supposed to be. So the right to prosecute in court, the right to plead law, sit at the bar and talk law belongs exclusively to legal practitioners by virtue of the Legal Practitioners Act in Section 24, Section 8, Section 2 of the Legal Practitioners Act. And once you qualify as a lawyer, you're entitled to practice in all courts in Nigeria. Thank you.
We thank you very much. Mr. Ozoke, do you have any further comments?
Yeah, the follow-up I'm going to submit is a very simple one, because Sylvester has pretty much clarified it. Because reading that particular provision of 66.2, it says non-qualified legal practitioners. Okay, it could so easily have said non-legal practitioners, but it says non-qualified legal practitioners. Those are two different things. Okay, you could be a non-legal practitioner, and that means you are not a lawyer. It's different from being a non-qualified legal practitioner, which means you are a lawyer, but you are not qualified to practice in this area, in this whatever nature of court they have. And that's why I asked that question. Are there courts in Nigeria? Because I know the nature of Sharia court up north. I'm not trained to practice Sharia court. I'm not trained in Sharia law, so I can't conceivably go up north and start adjudicating Sharia practice. I can't do that. So I want us to make sure, because this is a very serious matter, but I'm trying to play devil's advocate here. If we are going to embark on this, because this is going to actually involve a lot of activism and advocacy to get this taken care of, because this is an aberration. But before you do that, you want to make sure that you have all your grounds covered, so that this particular provision is not a technical hitch that you might run into, because a smart lawyer might actually argue that, look, non-qualified legal practitioners is different. It has a different connotation than non-legal practitioners, and that term qualified might actually be referring to some courts in Nigeria, which not every legal practitioner is entitled to by way of qualification to practice. So that's what I wanted to find out, and I think Sylvester has clarified that. And if that is the case, then it's all clear. Let's get it done. Thank you, guys.
Well, thank you very much, Mr. Zeke. I think you highlighted something that escaped some of our notice before, because we initially were thinking, what does it mean, non-qualified legal practitioners? So I think that's a good point for our erudite lawyers in the room to see seriously, and our legal draftsmen to seriously think about. Mr. Bethel, please, are you able to conclude your submissions at this point? Mr. Bethel Ihuba, please.
Hello?
Yes, go ahead.
Yes, can you hear me?
Yes.
Okay, thank you very much. Sorry, I'm taking off the camera because it's not going on very well.
Yeah, go ahead.
Yeah, I just wanted to conclude. This our fascination about the police. We need to, I think, pull it back a bit. Somebody made mention of repealing that legal provision. I am in total support of it. The police shouldn't have the right to prosecute, whether they are lawyers or not. That is my position. They should not have the right to prosecute, whether they are lawyers or not. There should be an independent body under the office of the Attorney General of a state or the federation that should carry out that prosecution. Let them stop at their rule, their statutory rule of prevention, investigation. Let them stop at that. That's where the rules start. And like the last speaker stated, in most advanced countries, most civilized countries, most constitutional democracies, that is how the police functions. Their job is to prevent and investigate crime. Once that job is done, they hand over, if at all a crime is found and there is a need to prosecute, they hand over the decision to the persons that have the authority, the lawyers that have the authority, the agency that has the authority to do that. That is my position. However, I just want to make other comments regards to the because the idea of, even though the title of the program talks about prosecution, before we get to prosecution, we have to investigate the crime. We have to find out that there's a crime involved. We have to ensure that we have failed to prevent crime before we get to prosecution. This new act made is more of aspirational. There are a lot of things that need to be changed in the act. The act is more aspirational than pragmatic. The first two sections talks about objectives. Those are not enforceable. They are just aspirations. There is no way you cannot enforce the objective for trying to be constitutional. They're trying to be enforced for the human rights. Those are already provided in the Constitution. The Constitution already stated that all citizens and residents have constitutional rights, fundamental rights that needs to be protected at all times. Repeating it in the Act as aspiration makes no difference. So you're just covering space. Then there's this issue of community policing. Somebody mentioned this earlier on, but it appears that we didn't pay more attention to it. Just talks about establishing community policing, but it is still a kind of a top-down approach, in the sense that it is still from the police that they appoint the members of that community police officers, more of a reporting a unit or committee, so to say. Community policing presupposes that the police officers, the members of the community police are from that community. They are able to engage with the community. They know what happens in the community. They have the presence of police in the community. They are more or less trying to prevent than to prosecute. But the way this the act is written, which we have not tried, we are all praising it, gives the impression that there is not. It is more or less a liaison of police. It's still a one-way traffic. But community policing presupposes a two-way traffic from the community to the police, from the police to the community. I think let me just stop at that point. Thank you very much for the opportunity.
We thank you very much, Mr. Ewere, for your wonderful submissions. Like I said, there are several other points in the Nigeria Police Act which I would like the discussants to address before we call on further questions from the audience, if you will permit me. Let's look at Section 4 of this. Okay, I received a question with that regard from one of our Dr. George Davidson. He pointed about Section 4. If you look at this Section 4 of the Act, subsection I, Section 4I, what does the new Police Act say about the role of private investigators? It said, vet and approve the registration of private detective schools and private investigative outfits. So just as we see in the movies or in the United States system, has this act created a role for private investigators? Do we start with who takes up? Any of our discussants can elect to. Okay,
if I may come in now.
Yes.
Prior to this time, there are still private investigators. Prior to this time. But this one gave a legal backing to it, and I don't see anything wrong with this provision. There are many times that we want to engage private investigators to help lawyers carry out some work, very much necessary. So, giving them the power to vet and approve registration, just like courier company, NIPOS ordinarily is in charge of it, but NIPOS give licenses to private courier companies. They register them to make sure they comply with the relevant extant provisions. So, giving the police the powers to vet and approve registration of private detectives, schools, and private investigative outfits, that will give impetus to people who are experienced in investigation. Because if they don't have that license, they may run foul of the law. And when they do their job, police may arrest them. So with this provision, it gives them the right to practice as private investigators once they have the license. I think it's a good development we have in this police act in this regard.
Thank you very much, sir. Any other discussants to speak on this question before we move on to other questions?
Yeah, in support to what Barrister Ogbah just said, we've always had them around. I could remember one or two cases, a family, somebody was killed and the police was involved, and the family still involved a private investigator who was working with the police, and at some point, the private investigator was having issues with the IPO, and they got to the point, who you be himself? What is their business with this case? Who are you? Which kind of investigation are you doing? So with this provision now, you could see even in one provision, they have given room for people to establish schools that will train private investigators.
Yeah.
By saying vet and approve private detective schools. So what it means that in one provision, they have now given room for people to be able to establish schools where private investigators are being trained. We don't have that before now, not to my knowledge anyway. The second one is you can now have a very big signpost saying Obunike Ohaegbu Private Investigative Outfit. People could now go into practice as private investigators openly. The people that were into it, probably people who came back, who were trained, former police officers, retired police officers. It has always been the exclusive duty, because of probably the person retired as a commissioner or a senior police officer. They give him that opportunity and privilege to be involved in the investigation. But with this provision now, I think it has made it legal that you could now, start business venture as a private detective firm, or start school exclusively for training people on how to investigate. And I think it's going to help our criminal justice system, because let me tell you, the major problem we have, the first one I mentioned was independence of the police. The second one is they don't have the capacity to do the job. Why we bother ourselves about the laws and all that? They don't have the capacity. In fact, most cases, if you have been involved in criminal practice, most cases, you find out that the facts the police we present in court were the facts they got after their arrest. So that's why they want to keep you for 1 month, keep you for 2 months, and continue to file amendment of charges and all that. So, but with this, I think the system will be a lot neater, because quite a number of people, I can tell you, will be more comfortable getting their matters investigated by private firms once it's legal. And I think it's a good development.
We thank you. Sylvester, you have omitted as well. Do you want to speak on this?
Yes. In fact, there's a very serious question that issue that's raised by Dr. Yuba, and that's very, very grave. So I would like to, just for 2 minutes, to speak on it. Now, Dr. Huber says police should not be allowed. There should be a blanket ban on police powers to prosecute. In other words, whether you're a lawyer or not a lawyer, once you're a policeman, you should not be entitled to prosecute. I beg to state that, with due respect, sir, this will create a serious confusion. Now, I would draw our attention to Section 4, subsection 1E of the Police Act. That's the act we are discussing. Section 1, section 4, subsection 1E. Now, we're talking about powers of the police. Under subsection, that's section 1, subsection 1, paragraph E of that act, paragraph E of subsection 1. Yes, it says, the police force shall discharge such duties within and outside Nigeria as may be required of it under this or any other law. If you look at the police powers, section 4, police provides powers of the Nigerian police. It is under this paragraph E that prosecution of cases in court is being accommodated, because it says other duties that are permitted by this or any other law. If this subsection E were not there, police officers wouldn't have been able at all, whether you're a lawyer or not a lawyer, it wouldn't be able to go to court to prosecute, because from paragraph A to the last paragraph, none of them talks about prosecution of cases in court. But under paragraph E, that could be accommodated, because that's other duties permitted by other law. The question to ask, the confusion that will be created if this act bans police officers, places a blanket ban on all police officers, whether you're a lawyer or not, is that you have to amend the EFCC Act, ICPC Act, because the reason most of our learned colleagues have cited is that you can't be an investigator and be a prosecutor at the same time. ICPC investigates, lawyers from their legal department prosecute. The same thing with EFCC, the same thing with Nigerian Customs, Nigerian Immigration, NAPTIP, Civil Defense, NDLEA, all of them, they're all they're investigation agencies, and they prosecute. But we all know, when you go close to them, you would understand that their structure is different. The way these agencies are structured, okay, shows that
those people that come to court to prosecute are actually not the investigators. Every government agency that investigates offenses like ICPC, EFCC, Nigerian Customs, the Immigration, NAPTIP, NDLEA, they all have legal departments. It is the officers in the legal department that conduct prosecution in court. Investigation of offenses or crimes is usually done by other people. Within Nigeria Police Force, the lawyers that prosecute cases in court do not investigate. They call them those in the legal department headed by the OC Legal. The OC Legal is the head of the lawyers that prosecute in court. What they do is to draft charges and prosecute cases. They don't investigate. So I think that the powers of the police to prosecute should be retained. Alongside, they should not be classified as special prosecutors, because in Nigeria, we have 4 classes of people that can institute criminal proceedings. The AG, who has the ultimate power, the police officer, the police, the special prosecutors, and the private person. So I think that police officers should be classified as special prosecutors, because those in the legal department are the people that prosecute. Banning police officers who are lawyers from prosecuting will do so much harm than good, because all other agents, that would be partiality, because EFCC investigates, its lawyers prosecute, ICPC and others, like I said. So I suggest that the best thing to do is to ban all police officers who are not lawyers from prosecuting. Let us start with that. As time goes on, if we have reason to call for total blanket ban, a blanket ban on these people, then it has to be done across board to apply to all agencies who investigate as well as prosecute. But we all know that the people that investigate within the Nigerian Police Force are not the prosecutors. Thank you very much.
We thank you. Please, our program normally runs for 60 minutes, but now this one, I'm afraid, will extend to 2 hours because of the importance of this subject. I hope our discussants will not object if we, but then once it reaches 2 hours, I don't think it's wise to exceed that 2 hours limit. So let's be mindful. Thank you very much for your brilliant submission. We have Otumba Olabode Osei is raising up his hand. Let's see, Mr. Otumba. Yeah, go ahead. What do you have to say on this topic?
Yeah, thank you very much, Dan. Well, I joined a little bit late, but with my little inside knowledge of policing, I think I can make a very small contribution. Looking at how policing or police structure is structured in Nigeria, all these legal structure that are supposed to back them up cannot be functional. It still will always lead to dysfunctionalities, because when you compare policing system in civilized country, take example of UK, there are almost about 40 different levels of policing. We only have one. I don't know how many levels we have, but the one that is common is you have police all over the place. Then the larger question again is what is in all these big draft of legal backup for the ordinary people? Most of the police are also archaic. They are not all that educated, so they create more problem than solving the problem of the ordinary people. So what's your take on this, the presenters? Thank you.
All right, thank you very much, Otumba. Otumba is practices in the United Kingdom. So any of our discussants do we get what Otumba has presented, and do you have any of our discussants can take up on the subject?
Okay, if I may be allowed again to speak on this issue. Otumba raised a very vital issue of the inexperience and uneducated nature of most of our police officers. It's a notorious fact. Most of them learn in the job, whether good or bad. And until we have a very good standard, that is, I'm not talking about as it relates to prosecuting a court alone right now. Well, you see Nigeria policeman standing on the road who is supposed to enforce the law. What is all about a particular day is how much I will take home. a police officer arrests you and is going through your phone to search what is in your account. You see a police officer going on duty, coming with a POS machine and compels you to withdraw money from your account. These are the issues we have.
Does that really happen? I've been reading about it. Sorry, Isaac, I've been reading about this in the social media. Does that really happen?
It happens every day.
24/7.
Nigeria police these days are not interested in arresting you and taking you to the police station. Okay, when I say Nigeria police work, I would rather use what majority of these police officers, when they arrest you on the way, they park by the wayside. What do you have for us? If you get to the court, you'll be charged 300,000. If you get to the police station, this is the offense. But if you want to settle, you're going to pay half of the amount. That is what happens. A typical police officer, a DPO who sends policemen to go to checkpoint, has an amount they must return back. That is the issue. So please, rather than address all these issues, we are chasing shadows. Just today, we thank God you have also published it also. The IGP banning policemen wearing mufti, banning policemen on patrol, such and also truth be told, is wanting to give a directive. Tomorrow you will still see it operational. Truth be told, we need a holistic reform, not just coming to dump a police act for us that will create more problem. If it is not more problem, why would we discuss that? This act has created more problem than solving some of the problem we are looking for. Thank you very much.
Okay, thank you very much, Adi. Let me point out another provision of this police act and see what the views of our discussants will be on it. Section 36. A person shall not be arrested in place of a suspect. Because remember we are discussing the implications of this crime, or of this new police act on criminal prosecution in Nigeria. Section 36. Is this a good, is it one of the good guys or one of the bad guys?
Now,
okay, somebody's in.
I think the SCJN has dealt with this.
Sorry, Sylvester, let's listen to Mr. Ohaegbu this time, please, because
all right, thank you.
Wanted to speak in the previous one, and yes, Mr. Ohaegbu, please.
I think it's a straightforward thing. There is no vicarious liability in criminal offense.
That is it.
It's a very simple one.
It's a very simple one. There's no vicarious liability. So,
okay, let's listen to. Okay, listen. Okay,
but the problem is this. That's why I say it's one thing to make a law, but it's one to enforce it. To date, despite the ACJA and ACJL of federal states making this provision, to date, they say arrest somebody in lieu of somebody. What has happened to date? That's the truth.
No, I think
the spirit of the law is not being implemented.
Lord Isaac, I think if we go down that route, we're not close to there because that is the normal. Okay, you made the reference to a police. It's not peculiar to police. Let me share something with you. A friend of mine who bought a federal government border vehicle, Prado, was driving from Lagos to. He was driving alone from Lagos to Anambra. And custom officers stopped him shortly before Benin, around Benin area. And they said, he said it was a government vehicle. They saw all the documents and they said, where is the waiver? They will need the contractor supply the vehicle to the federal government. The guy said he doesn't have that. He called me. I called the controller of custom. He said he's hearing that one. He told me he was hearing that one for the first time. A controller said he was hearing that for the first time. You know what happened? The guy, they demanded for 150,000. He didn't have that money. He didn't have that money. Then they directed him to the one shop, one butcher close by. Somebody was there with so many POS, whatever, specifically serving that custom checkpoint there. They said, oh, which bank? He told them the bank, and they gave him the POS for that bank. And they took 150,000. Of course, I told him to go and write his bank and all that. After some days, the bank they got caught up with this lockdown. So it's the problem we have. It's the problem we have as a nation. We have these fantastic laws. We have this fantastic. So it's a problem we have, you know. At the end of the day, you look as if it's like, initially I said somebody will now use it as campaign that I reform the police and look at what I did. If you drive down now, even within this Abuja, before you drive from now to Area 1, if you are getting to Area 1 junction as we speak now, you will still see those guys from SARS there doing their stop and search thing. They can't stop it. They've not gotten the signal.
Okay, we thank you very much. Can we look at section 32.1, please, of the new act, section 32.1? No, sorry, section 31. Pardon me, please. Section 31. And this time we will ask the lecturer among us to address that of Mr. Udemezue, please. Where an alleged offense is reported to the police or a person is brought to the police station on the allegation of committing an offense, the police shall investigate the allegation in accordance with due process and report its finding to the Attorney General of the Federation of a State, as the case may be, for legal advice. Is it the situation now, or is this an improvement?
Now, thank you very much, sir. There is a new provision in the police, the Nigerian Police Force Establishment Act 2020. But that section actually creates a confusion. Like I was just typing in response to Mr. Isaac Ogbah when he said that the new act has created more problems than the solutions it provides. And I was typing on the chat platform that I agree in total, because there's a lot of confusion. Now, how many offenses, how many reports are you going to send to the AG? So, because from the provision, even when there's a report on alleged affray, fighting in public, you must send the report to the AG for legal advice. There is no delimitation of the categories of offenses that in respect of which this kind of report should be made to the AG. We agree that under section 174 and section 211 of the Constitution, the AG is the chief prosecutor in this country. He has the power to institute, to take over from anybody, whether he's the person that started or not. But burdening the office of the AG with the job of giving legal advice in every single investigation in this country. In fact, it's like putting a stop to the working of the office of the AG. Because even the little work given to the office of the Minister of Justice, the AG's chambers, has not been effectively and efficiently discharged. In fact, it is on record today that, of course, experience has proven us right, that the office of the AG, that is Minister of Justice, the AG's chambers, they are a key contributor to delay in trials in this country because we don't have sufficient manpower. So the legal advice that the offenses or the categories of offenses in respect of which they have been given legal advice, have they been able to deliver in this respect? How can you now ask that every single investigation carried by the police, they must report to the AG for legal advice? How many offenses? If someone is accused of stealing, you must send to the office of the AG for legal advice. I think it's a serious problem. So when we talk about amendment of or expunging of provisions in the new Police Act, I think what they have done, like one speaker, I think Mr. Ohaegbu, when he was speaking, he said that what the act has done, what the lawmakers have done, is just to go and pick, copy and paste. You know, they just went to so many other laws, copied things there, and came and posted them here, without thinking about the implication of the practical implication of what they are creating. So I think that is a very serious problem created, because they say shall. Remember, here, shall. What that means is that today, if a Surulere police station in Lagos, where I live, if they prosecute a case, I mean, if they arrest anybody or investigate a case, and after investigation, they file a charge in court, I can bring a preliminary objection if I'm the defense counsel to say, you can't come to court because there has not been any legal advice. Because you are mandated to send the report of investigation to the office of the AG for legal advice.
So if there's no legal advice emanating from the office of the AG, prosecution cannot happen. That is what, so they have put, in fact, they have created a scenario.
Can I come in and make the,
they have created a scenario where lawyers cannot capitalize on this to begin to enter objections to trial in court. And then when there's a court declaration now, then they will not begin to send all files to the office of the AG, because I've looked at the session where an alleged offense is reported to the police. They didn't talk about the category of offense. Or a person is brought to the police on allegation of committing an offense. The police shall investigate the allegation in accordance with due process and report this. So an offense means any offense. It's a serious issue.
Please. There's an aspect to this issue that which I agree with what Udemezue says. However,
is it frozen again?
Oh no.
Mr. Uba, your beautiful contribution. Can you imagine? Okay. No, another person goes on why he comes back.
Actually, I tend to.
Yeah, yes. I was about to call you. Go ahead.
Yes, I tend to differ in their opinion because
there's an aspect to this which we have not recognized. It's not just what they do in other civilized they will now deploy. Hello, can you hear me?
Yeah, go ahead.
Hello, hello, can you hear me?
Yes.
Yes. So so that is the value of that. That is the value. And with the issue of waiting for a legal advice, the legal advice could be given before. There's a possibility within the police has the power to make regulations. So they can make regulations guiding how the requests for that advice can be used. So they can give advice beforehand. If the offense involves this kind of people, this should be done. So the issue of lawyers going to seek for a objection on that may not hold. So we shouldn't just take the import literally to that extent. It's not done anywhere. So the legal advice can even be given within the AG can give the OC in the department the power to give that legal advice. So it doesn't mean that the AG himself has to be the one to give the legal advice.
But there must be evidence that it was given. That's what we're talking about. There must be evidence that it was
Yes, sir. That is one aspect of it. You know, that can be delegated to somebody. So that may not really be. It will not be a problem. I actually see because we don't do proper. We don't check our. I don't know. The police generally don't do proper research on the confessions. This is what I just talked about. People collecting, holding POS. This may be happening in particular regions. So if we have this kind of report, the police will not develop a procedure for resolving that kind of problem. There's a sense of this kind of a provision. So I don't see it as a big problem, sir. Thank you very much, sir.
Mr. Thank you very much, Bethel. Emmanuel, please, quickly, because we'll soon be rounding up. Emmanuel.
All right. I see this as a very good law, but in a bad system, because the Nigerian system is completely bad. Why I say so is because now we have the office of the Attorney General fused with the DPP. The office of the Attorney General, being a political office, lack the capacity to give sound judgment that is devoid of conflict of interest. Now, this advice generally is predicated on contemporary practice. We see places like the US, Canada, Germany, even South Africa, practicing a system where the police will carry out the whole investigation, and after the investigation, they will hand over to a department that will look at the face of the whole evidence and know if there's a prima facie case and whether this should go to court or not. So, in this regard, I see it as a very good practice that will reduce frivolous cases in court. Nevertheless, in Nigeria, this will have little application because of the system is so mixed up and cannot promote good practice, except we change our system, except we separate the office of the Attorney General from the DPP, except we separate prosecution from the investigation of the police, then our system is mixed up and can never produce something good. That's my
We thank you very much. Please let me. Our time is running out. Let me highlight another provision of the law before we calling it a day. Can we look at section 35, please? If we can touch on that section 35, I'm particularly interested in section 35.3. Section 35.3. The authority having custody of the suspect shall notify the next of kin or relative of the suspect of the arrest at no cost to the suspect. Is it a new one or has it been in practice? What do you think of the subject? Can we take Mr. Ogbah, please? Can you, section 35.3.
Well, the section talks about police officers or those of the war notifying the next of kin or relative at no cost. I must say, with all sense of humility, the police seems to have been doing this.
Okay, that's fine.
I mean, in several cases I have been involved in.
All right.
Even when you don't even have a phone, they make contacts. That is the humane ones, but not in all instances.
But now it is now backed by law, isn't it? If it is now statutory, then.
So it's a commendable one. It's a commendable one. But where I'm still having issues is implementation. We have not been short of laws. The problem we'll be having in this country is implementation. We have some of the best laws in this country, but we don't implement them. So, but making it now statutory is quite commendable.
Right. Okay, Mr. Ohaegbu.
Can I say something about that?
Yes.
Well, probably because I've been privileged to head a government, a federal government agency. This law you are talking about now cannot be practiced. It cannot be enforced. Because if you're now saying that the suspect, the implication of this law is that the communication will be at the cost of the police. So what it means is that the police will make appropriation for that. What happens is that if the police, if they give you phone to make calls and that, at the end of the day, they will expect the money to be back. Who is going to pay for the calls? What it means is that the Nigerian government, for this thing to be enforced, for this thing to be practicable, there will be appropriation for billions of naira for communications to suspect relations.
All right.
We don't make provision for that. If there is no appropriation for that, how do we enforce it?
Okay, we thank you very much. So please, our time is up. Let's give the last 2 minutes, please. Please restrict it to 2 minutes. Our discussants, please. What do you think is the general implication of this new police act? What do you think? Generally speaking, good, bad, and impact on the human rights of suspects generally. Let's start with, okay, I think he's on for, okay, let's start with Ewere now and then continue to the end as the way we began. Mr. Emmanuel, what do you think about this new police act generally, its impact on criminal prosecution, and its impact on the human rights? We didn't go into that, but because I wanted us to discuss that, but there is no time. Its impact on human rights, and then your final take. In 2 minutes, please, and not more than that. 2 minutes.
Thank you very much. I think that the new police act has not done well in regards to making out a clear terms on prosecution. And nevertheless, they have a lot to do in that regard. They have to do, they have to work with modern trend, modern flow of criminal investigation, criminal prosecution, and criminal justice. If they really want to bring up justice, then they must work with modern trend. Then in regards to human rights, the Nigerian police is the most untrusted people in Nigeria currently. And people fear them even more than criminals. So looking at their primary objective of protecting life and property is really, really a doubt right now in Nigeria. And if they must do something about this, they let us see the enforcement of this law. This act that they have made, let us see the implementation, not just having it in paper. We want to see them for real, protecting humans, protecting their property. This is what we want to see, not just having it in paper. We want to see the police as our friend. Thank you very much.
All right, we thank you. Shall we take on Isaac, please?
Yeah, the problem we have in Nigeria, as I have said before, is implementation. Under the ACJA or ACJL, when suspect statements are being taken, there ought to be electronic recording of it. You ought to have the lawyer present. But today, the lawyer is sent out when the statement of his client is to be taken. There is no video recording. And suspects are beaten, tortured to make confessional statements. And that is still what will be admitted in court and used to convict the suspect. The question is, well, it does not end in making such laws. Laws have been made, making it mandatory for a lawyer to be present. Either his lawyer or a public lawyer provided for him. Today, is it being implemented? The answer is no. The law has been made. You must have a video evidence, electronic evidence showing when the statement was made to show that it was not made under duress. It's never been done. So to talk about other human rights, many fantastic laws have been made here. But in reality, the Nigerian police force we have will use their force to suppress the law and make it redundant. So please, let's have a holistic approach. Let every individual study this law. Let these laws be taught in our secondary schools, primary school, tertiary institutions, so that everybody knows their rights. When everybody knows their rights, we'll put the police under check. If it was not the social media campaign against the beating, the brutalization of people, would the IG have come up with this ban on SARS and other agencies? The answer is no. So please, we need to do much enlightenment on these laws. Let's point out the areas where the human rights are protected, and let's give people to be more educated about it. Educated people. The more emphasis we place on it, the more we will put the police under check. And to a greater extent, this law will be implemented. Thank you very much, sir.
Thank you. Mr. Ohaegbu, please.
Well, I think probably because of my practical experience with government agencies, something has been, the first question is, the Police Act we have today, is it better than the one that was amended? If you ask me my own personal opinion, I think something has been achieved. For instance, if somebody is appointed the Inspector General of Police today, he will not always be on, watching his bag that he could be removed today, he could be removed tomorrow. He already knows he has 4 years. Irrespective of his retirement age, it becomes a political appointment. Brings some level of stability. If you have actually had cause to collaborate with police in what you do, not just as a lawyer, to work with the leadership of the police, you know that this predictability and stability is very, very important. Today, we will have alternative. If you have something, if you can afford it, instead of getting involved with police, you get involved with private agencies, and know in the next few months, they will start springing up who can investigate the matter, and that will reduce the number of people you have at the police, the number of cases you have at the police station. Because once there is legal, whatever they get will be admissible in court. So I think an improvement has been made. It has not been provided that you could have records, fingerprints, and all the records of criminals. If you are investigating somebody, we could do more. There's always room for improvement. But we have moved from point A to point B, and we are hoping that we'll continue to improve on that. Gradual improvement is very important. That's why people like me are not happy that President Jonathan did not sign the amendment of the Constitution that would have separated the office of the Attorney General from the office of the Minister for Justice. But gradually we are making progress. It's an improvement from what we had before. So we are hoping to, improve more on this one.
All right, we thank you. Mr. Udemezue, please.
Thank you very much, Mr. Elombah, for this wonderful discussion. Now, my short comment to close from my own end, I would make a reference to that section, or the body that is to be created, the public complaints section of the police. That's not a new provision, because the police X-squad, their job from the time Nigerian police came on board, the police X-squad departments, their job is to receive complaints from the public in respect of activities of the police. Now, I would like to make my closing remarks based on section 66, subsection 3 of the Act. That's a very big welcome development. It says there shall be assigned
Section what?
to every section 66 subsection 3.
Okay.
66 subsection 3. Because everything is about negative. I agree with the last speaker, Mr. Ohaegbu, that says we have left where we used to be, although we have not arrived where we ought to be. So everything about the Police Act, the new Police Act, is not condemnation. Okay, we still have to point out the fact that there has been some improvement made. That's why I agree totally with the last speaker that says we have left where we used to be. We have not got to the promised land. So the sections, there shall be assigned, section 66 of section 3, there shall be assigned to every police division at least one police officer who is qualified to practice as a legal practitioner and whose responsibility is to promote human rights compliance by officers of the division. Now, I have two things to say about this. The first is to make reference to what I wrote about 2 years ago, and I repeated also last year, and I made it as a presentation before the NBA conference in Victoria Island last year. I would also make a reference to that because I think that that particular session, although is a big improvement, the purpose or object of that section might not be achieved unless we expand the number of police officers posted to that particular, to each police station. So I make this as my contribution in this respect, or my recommendation is as follows: that if the Police Act should be amended to provide for the setting up of a legal section, not just posting a police officer, set up a legal section to every police command, that's every police division in Nigeria. Each of the legal section to be headed by a divisional legal officer. A divisional legal officer who must be a qualified legal practitioner. Just as we have divisional police officer, DPO, divisional crime officer, DCO, divisional traffic officer, DTO. We should also have a DLO who would become the head of the legal section in the police division with the mandate to advise the DPO, the DTO, the DCO, and other men and officers of each police station on observance of human rights requirements in treatment of arrested people, and detainees, to draft criminal charges, first information reports, filing of filings in relevant magistrate courts, advising the police on what offense to charge to court and on what offense to not charge, and even on when to institute a charge and when to not institute. This would in turn decongest our courts, because fewer cases will be filed, because frivolous charges will have been weeded out at the investigation level. That is, besides, lawyer police officers would, from various legal sections of police divisions, would also participate in the prosecution of cases in magistrate court. This has two additional advantages. So there will be need to employ more lawyers in the various police stations, and thereby provide them the legal touch that they need to improve on their activities. Then number two, with lawyers as prosecutors in the various magistrate courts, and then advising the police division from the legal department, then we would now, of course, that would take care of what we have discussed, because we have already discussed the need, the advantages of having lawyers as prosecutors. So I think that that subsection should be amended to provide for the setting up of a section, because we have a DCO, we have a DTO. So all these people will not be reporting to the DPO, who is the head of this division. Sending only a lawyer to a police station when we know that more than 10 to 20 cases are reported to each police station in one day. One lawyer will not be enough, because we all know that in all the commands in Nigeria, all the police commands, the only place we have lawyers is in the CID, that is the headquarters, where we have the OC legal, and then we have maybe 5, 6 lawyers. One man called me from Lagos and said there are no more than 15 to 20 lawyers were in the legal section of the Lagos State Police Command. You understand? So if we have only one office for all to cover and advise all the police officers in one state, that is too poor. So I suggest that just as we have OC legal as the head of the legal section of the police command, this will also, we have DLO as like branch heads at various police stations. And then lawyers will be employed under the DLO. So each legal section will be headed by a lawyer, and then we'll have up to 3, 4, 5 lawyers employed under him. That is the only way they can handle the volume of work
that should be handled. Because if you look at a police station, let us talk about Bar Beach Police Station in Victoria Island, for example. You send one lawyer, the lawyer may be 5 years at the bar. What can he do? You receive more than 20 cases every day. How many pieces of advice can he give?
We thank you.
That will now lead us to delay. Thank you very much. God bless you. So I thank you for having invited me, and I thank all of us for the contributions that my colleagues have made. I enjoyed the discussion. I enjoined Elombah TV and Elombah publishers to continue to bring up these issues that they will help the Nigerian legal system and the Nigerian system generally. Thank you very much.
Thank you very much.
We thank you. On a final note, I would like to say this as well. I've had discussions where this, not quite too long ago, the Nigerian government passed the New Companies and Allied Matters Act, and now the Nigeria Police Act. And whenever these new bills are signed into law by the president, all sorts of permutations and controversies will follow these new laws. And the question I asked concerning the newcomer, I'm also acting regarding this new Police Act. We know that bills are submitted to the National Assembly. It passed through several legislative processes, one of which includes public hearing. If the civil society is doing their part whenever these laws are moving from one step to another, so that these issues, these controversies that normally come up after the fact can be discussed or critically appraised during its formative stages, so that we wouldn't have these appeals to, either amend. Isaac, Ogbah, you want? Sorry.
The truth be spoken. During this public hearing, these issues are raised, but politicians, be who they are, they do this public hearing for formalities. What they want to do, they will do.
All right.
That is the truth. So it is when it is passed into law, we begin to attack. When you have an advisor, governors have over 300, at least 1,000 advisors. When they advise him, does he listen? The answer is no. Okay. So please,
all right.
While I will blame NBA at times also for not doing their job properly, but many a times, because if we have people representing NBA in CAC, before those laws were passed, did they draw the NBA attention to it? This is what have been passed to National Assembly. The answer is no. Most of these agencies, we have representatives. We have civil society groups who are aware of what this is for. Many times, instead of informing the agency they are representing what is happening, they don't.
Okay. All right.
But when they are given advice, they still do what they want to do. So let us wake up. Let's challenge most of these laws in court and let the public make a pronouncement on them.
We thank you very much, Mr. Isaac Ogbah, Principal Partner, Ogbah Isaac & Co. He's also the Editor-in-Chief, Erudite Judgments of the Supreme Court, which has added much to legal knowledge among practitioners in Nigeria. Thank you for being with us tonight and for your wonderful presentations. Thank you. We also thank Emmanuel Ewere, who has a regular appearance on our program, International Business Law Expert, and of Advocate Lawyers, Abuja. Thank you for being with us tonight.
Thank you very much, Mr. Daniel. My very big pleasure.
Obunike Ohaegbu, a friend of Elombah Television and managing partner, St. Phil Associates, Abuja. We thank you for being with us tonight. Thank you. Still there, Mr. Sylvester Udemezue, please. Thank you. We have always enjoyed.
Yeah, thank you for having me.
Oh, okay. Okay, thank you. Mr. Udemezue, we have
left my office, so.
All right, Mr. Udemezue, thank you very much. We have always enjoyed publishing your articles on our news portal. So we are happy to finally see you here, and thank you for being with us tonight.
God bless you, and I thank everybody that attended. God bless you. Thank you.
We thank you, all our listeners, for your wonderful contributions. Otumba, thank you very much. Joe Onyekwere, we know you are here. Hopefully, please report our findings on The Guardian. Joe is the judicial editor of The Guardian, if I'm correct. Joe, thank you very much for being with us tonight. And all other listeners, thank you all. And we hope to see you once again when we have a similar topic on any legal issue. Thank you and good evening.
Thank you very much.